Welcome to this training on understanding the various types of legal relationships in Ohio for kinship caregivers. If you're a grandparent, aunt, uncle, or family friend caring for a child who isn't your own, this training is for you. My name is John Altman, and I'm an attorney with the Legal Aid Society in Cincinnati. I'm a member of the Legal Aid's Kinship Care Team, where I provide support to kinship care providers in establishing legal relationships with children in their care. Our work at Legal Aid helps provide both financial and emotional stability for children and families in kinship care relationships. We know that navigating the legal system can feel overwhelming. That's why we're here to help you understand what kind of legal relationship you currently have, as well as other legal relationships that exist. Because every situation is unique, this training provides general information, not legal advice. You're encouraged to talk with an attorney for advice about your personal situation. If you need help finding an attorney, Ohio Can Navigators may be able to refer you to a legal services provider. Let's start with what kinship care means. Kinship care is any arrangement where a non parent, either biologically related to a child or not, has taken over the care of a child whose parents are unable or unwilling to provide full time care for that child. This arrangement can come about in a number of ways. There may be a court order. This can be privately filed by the caregiver or filed by a public children's services agency in a case involving the removal of the child from the parent's care because of concerns about the health or safety of the child. There may also not be a court order. This includes any situation where the kinship arrangement is not established by a court order. This can include voluntary arrangements made by the biological parents and the kinship care provider, or situations where Children's Services is involved but has not filed a petition in court, such as a safety plan, which is a voluntary plan for the child to stay with a kinship caregiver while the bio parents participate in supportive services and take steps to resolve conditions that present immediate threats of harm to the child. Let me tell you why legal relationships matter. There are many reasons caregivers might want to establish a legal relationship with the child or children in their care. This includes, but is not limited to, helping to alleviate an immediate safety risk to the child, getting medical, dental, or mental health care for the child, enrolling the child in school, accessing certain public benefits, or simply providing a greater sense of permanency and stability for the child. The type of legal relationship you have with a child in your care will determine several important issues, including who has permission to make medical and education decisions for the child, whether the biological parents are permitted to see the child, and the level of permanence of the caregiver's legal relationship. Let's start with an overview of the different types of legal relationships. You can think of these on a spectrum of authority and permanency. At one end, there are short term arrangements that are easier to set up or change. And on the other end, there are permanent legal decisions that give the caregiver full responsibility for the child. Every caregiver situation is different. Having a clear picture of the options can help you understand where you stand more quickly and feel more confident when talking with professionals like caseworkers, teachers, or attorneys. Let's walk through each of the legal relationships, starting with the more temporary arrangements. A grandparent power of attorney, also known as a GPOA, is a document prepared by a parent temporarily sharing some of their legal decision making rights with a grandparent with whom the child is living. The document is not intended to be permanent and can be withdrawn by the parent at any time for any reason. Having a grandparent power of attorney does not prevent the parent from contacting the child whenever the parent chooses. For example, a grandparent power of attorney may be helpful when a parent is out of the country due to employment, military service, deportation, or when incarcerated or hospitalized. You do not need an attorney to complete a grandparent power of attorney. After it is completed and notarized, the parent must file it with the juvenile court in the county where they live. As the kinship caregiver, this tool would be useful for you to present to a school at enrollment or to medical providers when seeking medical care for the children in your care. A caretaker authorization affidavit, or CAA, is very similar to a grandparent power of attorney, but instead of being prepared by the parent, it is prepared by a grandparent with whom a child is living and is filed in juvenile court. The grandparent can only file this document if they've been unable to locate the child's parent, legal guardian, or legal custodian. The grandparent will have to provide a sworn statement that they have made reasonable efforts to locate the parents and have been unsuccessful. Currently in Ohio, only grandparents can file this document with the juvenile court. Other caregiving relatives or family friends cannot use this document to gain decision making authority. The document is not intended to be permanent and can be withdrawn by the parent, guardian, or custodian at any time for any reason. You do not need an attorney to complete a caretaker authorization affidavit. After it is completed and notarized, the grandparent must file it with the juvenile court in the county where they live. As the kinship caregiver, this tool would be useful for you to present to the school at enrollment or to medical providers when seeking medical care for the children in your care. Legal custody is a legal status provided by a court. It is meant to be a final order that gives a custodian the right to make legal decisions about the child or children in their care. For kinship caregivers, this means that they take over legal decision making authority from the parents. This typically includes decisions about medical care and schooling. Custody proceedings are initiated in one of two ways. One way is when the state of Ohio removes a child from the physical care of the parents and files a case in juvenile court because it believes a child has been abused, neglected, or dependent. That's called an abuse, neglect, or dependency case. A child may stay with a kinship caregiver throughout the abuse, neglect, dependency court case, but the express purpose of the case is to reunify the child with the parents. The goal is to provide services to the biological parents so that they are put in a position where it is safe and healthy for them to care for their child and ultimately regain custody. When reunification with biological parents is not possible, an abuse, neglect, and dependency case may result in a final order granting custody to a kinship care provider or the termination of parental rights followed by adoption through foster care. The other form of custody proceedings is a private custody case, where a caregiver like you files a petition for custody with the court. Unlike in an abuse, neglect, dependency case, the caregiver is a party to the case and has the burden of proving that the biological parents are unsuitable or unfit to care for the child. At the conclusion of the custody case, the court will issue a custody order awarding one or more parties legal custody of the children. If only one party is awarded legal custody, that party has the sole right to make legal decisions for the child. If two or more parties are awarded legal custody of a child, those parties have what is called shared parenting. These parties must work together to make legal decisions for the child, and typically no one party can make a legal decision without the agreement of the others. The court may also issue a parenting plan, which is occasionally referred to as a visitation plan. That plan details the child's day-to-day care, including where the child will physically live, what school district the child will attend, and when and on what terms the caregiver and biological parents will spend time with the children. Legal custody is intended to last until the children turn 18. For that reason, it can be difficult for a parent to regain custody once someone else has received legal custody. They must prove that there has been a change of circumstances since the original custody order. This change in circumstances must be in the life of the child or custodian, not in that of the parent. The parent must also prove that it is in the best interest of the child for the parent to have custody. However, a custody agreement can be changed by agreement of all the parties involved. For example, some parents are not able to care for their children because they are struggling with a substance use disorder. A court might grant legal custody to a grandparent caring for a grandchild whose parents are actively using drugs and unable to provide a safe, healthy home for the child. If later the parents stop using drugs and enter recovery, they might be more stable and have capacity to safely parent their children. However, to make a change in custody, the court would look at whether or not the child's circumstances have changed. Even if the parent's circumstances have dramatically improved, the court will presume stability and consistency are in the child's best interests and may not be persuaded to change the legal custody order. In a case like this, the parties might choose to adjust the parenting time plan to ensure that the biological parent is able to participate more fully in the child's life without affecting the official custody order. You may initiate a private custody case without an attorney, but it is in your best interest to consult with one before you file. An attorney can give you legal advice specific to your family's circumstances and help you prepare for court proceedings. Your county juvenile court may have a clinic or help center where you can get free legal help. Also, if you need help finding a family law attorney, Ohio Can Navigators may be able to refer you to a legal services provider. In Ohio, there are two types of guardianships for children. The first is guardian of the estate, which is legal authority granted by a probate court to manage a minor's assets, typically money from an insurance policy or personal injury settlement. The second is guardian of the person, which is legal authority granted by a court order that gives the guardian the responsibility to care for a child and ensure their needs are met. The guardian has physical custody of the child. It will only be granted if the probate court finds that the minor's parents are unsuitable. The guardian is required to file regular reports to the probate court about how the child is doing and whether the guardianship is still necessary. Guardianship provides more security than a power of attorney or caretaker authorization affidavit, but it is not a final order and is not necessarily meant to last until the child turns 18. Guardianship is not typically recommended unless the child has assets that must be administered. For example, following an auto accident, a child might be awarded an insurance settlement. In that case, a guardianship of the child's assets, that is, the money from the settlement, would have to be opened in probate court. The guardian of the minor's estate must seek court permission to spend the child's money and must file periodic accountings of the spending. You may initiate a guardianship case without an attorney, but it is in your best interest to consult with one before you file. Probate court proceedings are complicated and require detailed accounting. If you need help finding a probate attorney, Ohio Can Navigators may be able to refer you to a legal services provider. Adoption is a legal process that ends the legal relationship between a child and the biological parents, terminating all parental rights and responsibilities. At the same time, it creates a new parent-child relationship between the adopted child and the petitioner, including making a permanent change to the child's birth certificate. The adoptive parent has all the rights and responsibilities as if the child were born to them. The relationship is permanent and legally binding. In an adoption, biological parents cannot file for modifications to the court's orders in the same way that they can with a custody order. A petition for adoption must be filed in probate court. A caregiver cannot file for adoption alone. It must be done through an agency or an attorney, often following a case in which parental rights have been terminated. Adoption is not always an available option for kinship caregivers. Specific findings must occur before an adoption will be finalized. If the biological parents do not consent to an adoption, then a child can only be adopted when 1. The parent's rights have been terminated by the juvenile court, or when the parents have entered a voluntary permanent custody surrender agreement with a public children's services agency, or 2. The court finds by clear and convincing evidence, a higher burden than most civil matters, that the parent has failed without justifiable cause to have any significant contact with the child, or has failed to provide for the child's maintenance and support as required by law or court order. Either of these requirements must have occurred for at least 1 year immediately preceding the filing of the adoption petition or the child's placement in the petitioner's care. Adoption is typically more complicated and expensive than filing for legal custody and may not be the first option to consider. The type of legal relationship you have with the child in your care doesn't just affect decision making, it also affects what benefits and supports you may be eligible to receive. In Ohio, many public benefits have the word kinship in their name. Some forms of support, like certain financial assistance programs, are tied to the type of legal kinship relationship in place. Some Ohio benefits are only available to kinship caregivers who are caring for children placed with them by Children's Services in connection with an ongoing abuse, neglect, dependency case in the juvenile court. Others are only available to kinship caregivers with a final custody order who have finalized an adoption. The attorneys I work with understand that assuming the responsibility for the care of someone else's child comes with many questions and needs. In some cases, caregivers may not be aware that the challenges they are facing with benefits, housing, health, education, or personal safety may have a legal solution. It is helpful when meeting with an attorney to bring any potentially relevant documents or correspondence with you. Also, please know when you meet with an attorney, what you share with the attorney or their staff about your situation is protected by attorney-client privilege. This means it's confidential between you and them unless you ask them to share it on your behalf. We can help best when we understand your circumstances fully. We also understand that legal matters are just one area where you may need support. We've found that Kinship Navigator programs like Ohio Can are a great source of help to the caregivers we serve. If you have currently stepped up for a child or find yourself in that role soon, please consider reaching out to a Kinship Navigator to explore the kinds of help that may be available to you and your family. Thank you.